Hello, my name is Steve Rosenthal, and today we're going to be discussing benefits and compliance, your roadmap to success. Before we begin, I'd like you just to take a quick read of our disclaimer. And please just take 15 seconds or so to read through it. Terrific. So good afternoon. My name is Steve Rosenthal, and I'm the CEO of Triton Benefits and HR Solutions. I want to thank everyone for attending today's seminar, which will also contain continuing education credits that we'll be covering at the end of the presentation. We are fortunate to be co-hosting this seminar with the prestigious law firm of Nixon Peabody, who in 2024 is ranked as a top one-tier law firm by Editor's Choice Best Law Firms magazine. They also have 11 of their 100-plus attorneys ranked as Best Lawyers of the Year for their core competency. The firm has experience in almost all aspects of law, and notably, top law firm when it comes to government compliance. They have offices in most major cities across the U.S. Representing Nixon Peabody today will be Mike Lingle, Eric Paley, and Lena Gionette. We also have presenting today Triton Benefits, who's ranked top 50 insurance brokerage firms in the nation. Triton manages over $700 million in annual premium, works with all the major carriers, insures about 75,000 employees with over 900 clients. Both Anthony Farinella, who is our VP of Sales, and myself will be discussing executive benefits and what we see as the future products when it comes to group medical insurance. Your voice control is set on off mode, so we can get through this presentation, but we encourage you to type in any questions on your control panel, as we will get to them at the end of the presentation. Upon email request, we will also be sending out this presentation. Now, without further ado, Michael Lingle will be kicking off the presentation discussing pay transparency.
Thanks, Steve. Welcome again, everyone, and thanks for attending today. So I'm going to start with an overview of some pay transparency laws. It's sort of a developing area in employment law, and it's been an active area among state legislatures passing pay transparency laws. And in general, a pay transparency law requires certain disclosure in job postings and advertisements. Now, the idea behind these laws is it's a way to promote pay equity. The theory being that if individuals have additional information concerning pay, they can make better decisions for themselves and have an understanding as to whether or not they're being treated fairly. So there is some research out there to suggest that pay transparency laws have reduced gender pay disparity. I couldn't find the references exactly for the 20 to 40%, but I did see an article quoting that. So there's at least some evidence that pay transparency laws have the desired effect. If you're in a jurisdiction where either there is a pay transparency law or a jurisdiction where one is being considered, it's a good idea to get ahead of that particular issue. Once it comes into effect, there's going to be additional information available both to your workforce and to applicants concerning the pay that you offer to employees. And so you'd want to consider what effect that will have on your existing workforce. What will they think of that information? And what might they ask as a result of it? So you would want to take a look at what you're paying, and then you're going to want to take a look at, do we have an issue with respect to pay equity among our workforce? So one thing that employers may consider doing in anticipation of a pay transparency law is a pay equity audit, just to get ahead of that particular issue. And because these trends are likely to continue, more states, more localities are likely to pass similar legislation. It's a good idea to get ahead of it anyway, and just a good employment practice to make sure that your pay practices are equitable. So our next slide lists some jurisdictions that already have pay transparency laws. You can see a number of states, and then there are some localities that have also passed pay transparency laws. They all vary a little bit, so it's a good idea to take a look at the particular law that would apply where in your jurisdictions where you employ individuals. But for purposes of today, and we also have a list of additional locations where pay transparency laws are under consideration. So if you're in these jurisdictions, keep an eye out. From what I can tell, though, if you are in Hawaii, not only are you lucky to be there, but you're also likely to have a pay transparency law coming on the books effective as of the new year. So something to take a look at there. I want to provide a couple of examples of what these laws require, what they look like. Practicing in New York, I thought New York might be a good example. So in New York, any job advertisement for a promotion or a transfer opportunity or a position where the position will be performed at least in part in the state of New York, that advertisement has to include the compensation, so the exact number, or a range of compensation. It also has to include a job description, unless the position title basically covers the job duties. So for example, if you post a position for dishwasher, you wouldn't need to include a position description. Dishwasher pretty much covers it. And then the DOL, the Department of Labor, also encourages employers to include in their advertisements other forms of compensation. But those other forms of compensation cannot be used in stating the range of compensation. So for example, you couldn't put a certain value on benefits that you offer and increase the range of compensation to include those. The range of compensation is just the hourly rate or the salary that you, in good faith, are going to offer for the position. So the statute includes some particular definitions. So a range of compensation means the minimum, maximum annual salary or hourly range of compensation determined and made in good faith. So good faith, of course, is further defined to legitimately, that the employer legitimately believes it is willing to pay. And there are various factors that an employer may take into account in determining that range. So such as the job market, the current compensation levels of employees, its hiring budget, and the experience and education levels of the employees. There's also definitions for advertise. It's very broad, of course, any written or electronic description or job advertisement. And at least in New York, it also has broad coverage in that if the position is going to be physically performed, at least in part in New York, it's covered. So that would cover remote workers if the employee reports to an individual whose work site is in New York. So as you can tell, it has a pretty far-reaching effect. In New York, employers with 4 or more employees are covered, except for temporary help firms that are hiring employees to place elsewhere. Government agencies are excluded. But with 4 or more employees, it's also a fairly large swath of employers covered in New York. The statute also specifically provides that localities can have their own laws on pay transparency, and several do, including New York City, Westchester County. Ithaca has its own law. And violations in New York, the law is enforced in general by the Commissioner of Labor, and there's civil penalties for violations. But notably, there's no private cause of action in New York, which is a somewhat helpful provision of the law. So that's an overview of New York. And again, you can see that the idea behind the law is to provide information to individuals and to applicants, so they have a pretty good idea about the compensation level offered by the employer. As another example, California also has a pay transparency law covering employers with 15 or more employees. And so in a job posting, including if you use a third party, you have to include a pay scale, which means a salary or hourly wage range that the employer reasonably expects to pay for the position. But you don't need to include other compensation, somewhat similar to New York. If an individual thinks that the law was not followed, they can file a complaint with the Commissioner of Labor or a civil action for injunctive relief and other remedies if the court deems those appropriate. And then employers, again, are subject to civil penalties for violations of no less than $100 and no more than $10,000 per violation. So again, you can see that just even between New York and California, there's some variation between the states. I've also seen variations whether or not the statute would cover internal job opportunities. So if there's going to be a position open internally, whether or not the posting would need to include a salary range. In New York, for example, it does, but that would be something to check, and that does vary state by state. I would say as a practical matter, not only getting ahead of this issue, so if you're in a jurisdiction with pay transparency laws or anticipate that's a possibility in your jurisdiction, getting ahead of that, as I mentioned, right away, or once you have job postings, making sure that you have the documentation and information that you used, for example, in New York, in good faith to determine the pay range that you've stated in your job description. What are the documents? What is the information that you used to make that determination? So that if you're challenged by the Department of Labor in the future, you have the backup there to support your position. So I know that we're saving questions to the end, but that's a quick overview of a developing area in employment law and pay transparency. And with that, I'm going to hand it over to Lena.
Thanks, Mike. So Eric and I are going to shift from talking about employment compliance to benefit-specific issues that you should be aware of. As ERISA attorneys, 99% of our practice focuses on federal laws, but I am going to continue talking about state and local rules as they do crop up in the benefits and group health plan world from time to time. So in the past few years, we've seen local ordinances come into effect that require some sort of healthcare coverage or money towards healthcare for certain employees. And the latest on our radar is an ordinance in Seattle that's applicable to hotel employees. So if you're in the hotel industry, you have at least, if you operate large hotels in Seattle with at least 100 guest rooms, or you enter into contracts with hotels in Seattle to provide on-site services like parking or restaurants, this could affect you. And what it requires is pretty significant contributions on a monthly basis to pay for healthcare. And that could be in the form of cash compensation to employees or contributions to their health, to the employer's health plan, contributions to an FSA or an HSA. And the rates that you're required to contribute increase depending on the employee's family size. So you can see here the rate is $530 a month for just an employee, and then it goes up pretty significantly from there depending on whether they have dependents, a spouse, a domestic partner. This has been challenged as being preempted by ERISA because employers have said, hey, we offer a group health plan. It's governed by federal law. Shouldn't that trump this requirement? How can we be expected to have uniform plan administration if we have to comply with every local rule that pops up around the country? So this was a court case that went up to the Ninth Circuit. The court disagreed with the employers and said, This doesn't require you to establish any sort of health plan. It doesn't necessarily affect the health plan. You can comply, employer, by simply paying extra compensation to employees to cover their healthcare expenses. So for now, this rule is in place. It's something to be aware of if you're in the hospitality industry and you operate in Seattle. It's going to create some additional work for you, that's for sure. And then another ordinance, this one's been around for a while. Along the same lines, oh gosh, what happened to the slides? Let me jump back. Sorry about this, everyone. You got a little preview of the whole presentation. Keep going back. All right, we're almost there. Oh. Okay, sorry about that. Yeah, so this ordinance applies to employees in San Francisco. It requires a minimum spend amount on healthcare for those employees. It doesn't matter the industry, unlike the ordinance in Seattle. It just applies to employers with 20 or more workers. And again, these contributions have to be made towards health insurance or reimbursement for medical expenses. And there's some pretty burdensome annual reporting requirements that go along with this one that you may be aware of if you have operations in San Francisco. All right, switching gears, I wanted to next touch on Medicare considerations if you sponsor a group health plan. This slide really just contains a refresher on Medicare and the various parts. I did want to note that entitlement to Medicare is it's sort of a term of art. You'll hear that term, and it doesn't mean that someone is entitled to Medicare just because they are age 65, for example. Entitlement means they are eligible by virtue of age or disability and enrolled in one of the parts of Medicare. So these terms become important when we're talking about this next slide and HSA eligibility. So there's a nuance you have to be careful of if you have a high deductible health plan with an HSA. The reason for this is that once an individual is entitled to Medicare, so they're eligible and they're enrolled, they can't contribute to an HSA. So if someone waits to enroll in Part A, their entitlement is generally retroactive to 6 months prior. So where this can become an issue is if someone contributes to an HSA and then applies for Medicare. So let's say someone on your HDHP plan is age 66. They decide, I'm going to apply for Medicare next year. They start contributing to an HSA. In July, they apply for Medicare. That coverage is retroactive to January. So those contributions they made all along for 6 months of a year would be ineligible. They would need to be distributed to avoid excise taxes. So it's a nuance you might consider communicating in your open enrollment and your other emails to participants to make sure no one's caught off guard if they're considering enrolling in Medicare soon. And then another nuance with Medicare that sometimes trips up employers is the coordination of benefits rules. So someone's covered by both Medicare and a group health plan. Which plan pays first? That we'll get the slides to after. Generally speaking, though, if you're a large employer, your group health plan, generally speaking, is going to be the primary payer there. And then again, those same rules that dictate which plans pay first dictate that employers can't take someone's Medicare entitlement into account when they're thinking about their group health plan. So they can't terminate group health plan coverage, provide less rich health plan coverage to Medicare entitled employees, charge higher premiums there, require longer coverage wait time, and then unless they're a small employer, so if you have 20 or less than 20 employees, you may be able to get creative here, but otherwise you can't incentivize someone to enroll in Medicare over the employer's group health plan. All right, I am going to turn things over to Eric.
Thanks, Lena. I will try to prevent the runaway train of slides here, doing what it did to you. So yeah, we're going to take a short detour here into the land of COBRA, and particularly COBRA litigation. It may surprise a lot of you. You know, COBRA has been on the books since 1985. I don't think it's gotten any easier to administer since then, and causes lots of angst for employers, which is one of the reasons that so many of them offload that responsibility to third parties, though some of you may well handle COBRA compliance in-house. But you'll see from this slide over the last several years, last 7 years, in fact, there's been a particular spike in a series of lawsuits, COBRA class actions that have been brought against employers. And that's what I want to alert you to, not because you necessarily have to assume that you've got a target on your back and that you're going to be the next in line. As you'll hear, unless you're a particularly large employer, the likelihood of being sued for something like this may be relatively small. But at the same time, it's that old adage, you know, hope for the best, plan for the worst. You really need to take stock of what's going on in your world regarding COBRA so that you're not caught flat-footed. And frankly, it is the law, so you should be mindful of how things are being handled. I'm also going to give you a little overview or a little taste, if you haven't heard my spiel in the past for some reason, about class action litigation and how this all works. So, as I've noted here on the slide, since 2016, we've seen at least 70 class actions. And maybe you look at that and say, well, that doesn't sound like a high number, Eric. But the reality is that the putative class, the number of people actually named in these class actions, can number into the thousands. So you're really hitting a pretty significant number of employees who are alleged in these lawsuits to have been harmed in some fashion by failed COBRA administration policies. And you'll see as well that the statutory penalties can be as high as $110 per violation per day, and that's per employee. So you can see how quickly the actual damages can mount, which is why these class actions are so attractive to the attorneys. The settlements have impacted classes, and this is dealing with employers anywhere from 900 covered lives up to 92,000 covered lives. So, you know, it's a pretty broad range of employers being hit. So if you're looking at this again and saying, boy, I'm too small, well, you're probably right. It's probably not worth the plaintiff's bar's time and attention to come after you. But by the same token, if you're, you know, looking at yourself and saying, boy, we've got 1,000 employees, well, you might well be in the sweet spot where somebody could come along and file some sort of strike suit against you and try to exact a settlement. And you'll see here the settlements have ranged anywhere from $65,000 up to $1.6 million. And if you know anything about plaintiff's litigation to begin with, you know, typically look at any of those numbers and multiply by 33%, and you're going to get some sense of what the attorneys themselves are walking away with versus what the actual participants and other plaintiffs are walking away with, which is usually a pretty nominal amount. But let me back up and just give you again my spiel about class action litigation for those who haven't heard me rant before. Class action litigation is, with all due respect to those on the plaintiff side of the bar, you know, it's a factory. It's a game. The goal is to go around and try to file as many of these suits as you can to try to get some sort of legal precedent of any sort in your favor with a judge that you can then use to go around to other companies who haven't been sued yet and try to exact very quick settlements. Why do I say very quick? Because class action litigation is very expensive, both for the plaintiffs' firms that bring it, as well as the defendants who get sued. But when you're a plaintiff's firm, typically you're running these cases without getting any payment whatsoever. And so you're funding it yourself, you're funding a law firm, and the sooner you can get a settlement that will keep the lights on and frankly fund the next several lawsuits, the better off you are. So it really is a factory. The key for a class action law firm, a plaintiff's firm though, is to try to get past the very magical motion to dismiss or motion for summary judgment stage. Why is that? Because filing a complaint is, you know, takes some time, but you're going to incur some costs, but it's relatively easy from a defendant's perspective just to file the response to that. But if you are the plaintiff's law firm and you can kick up enough dust to make a judge and the judge's clerk sit back and say, maybe there's something here, I need to hold this over for further investigation, you've now hit the jackpot, because once you hit the discovery phase, which is what comes next, for a defendant, it quickly devolves into a calculation of how much money do we have to spend to get out of this thing as quickly as possible, because discovery and depositions and all that is going to be insanely expensive. So from a COBRA litigation class action perspective, the idea here I want you to keep in mind is, what's the least amount that we can do as a plaintiff's law firm to kick up dust and get us to survive a motion to dismiss or motion to summary judgment? So if I go to the next slide, oops, not too far. These are some of the issues over the last 7 years that have been raised by the plaintiff's law firms. And I keep referring to the plaintiff's law firms as opposed to the participants, because I'll be honest with you, a lot of what goes on with these cases is not necessarily going to be raised by one of your employees when they leave. A lot of times what goes on is that these larger law firms, plaintiff's law firms, will go fishing for plaintiffs and say, hey, have you recently separated from your company? We want to talk to you about bringing a case where you could potentially make some money. And that's how they largely get started. Sometimes they get started by somebody who terminates and speaks to an attorney, and the attorney senses that there's an opportunity, but a lot of times it's through these fishing expeditions. But right here, let's get to the substance. These are some of the claims that get raised in these COBRA class action litigations. And you can tell at a glance, the bar is set pretty low, but you really have to sort of slice and dice to understand the sort of mundane issues that can be raised, whether it's preparing the notice in a manner that hasn't been written in a way that's understood by the average plan participant. Bear in mind that the Department of Labor has long issued a model election notice. Doesn't mean you have to follow it verbatim, and there are a lot of good reasons why you might stray from it in one reason or another, but on the whole, if you follow that, the argument would be, well, if it's good enough for the Department of Labor, it should be good enough for the typical plan participant. But some stray too far, and the allegation is made that it's not written in a manner that can be easily understood. Maybe it doesn't properly explain the enrollment process, or give the enrollment deadline. You may not include a physical election form. You may not include basic information about the names of the plan administrator, the COBRA administrator. The list goes on and on. I don't need to read each one. But again, at the bottom, I'd say the second from the bottom is, bear in mind that if all else fails, the Department of Labor has a model election notice. They've updated it from time to time as the law has changed. But on the whole, the law has been around since 1985. I won't say that administering COBRA is not complex. It certainly can be. But with a few simple tweaks, you can find yourself pretty well out of harm's way by making sure that things are done properly. And that's where I want to leave you in this part of the conversation, with some simple takeaways. Again, plan for the worst, hope for the best, but don't assume that everything is being done on your behalf correctly. First of all, you want to take stock of your internal COBRA processes. If you're handling COBRA yourself, you want to review your current forms and make sure that they've kept up with the changes in the law. You want to make sure that you can check off some of the boxes I raised on the prior slide and make sure that they're satisfying all of those requirements. And if you're not handling COBRA internally, you want to lean on your outside COBRA vendor, whoever it might be, and engage with them to make sure that they are procedurally complying with COBRA on your behalf. Because even though they certainly have a service agreement with you to do that, at the end of the day, you're still the one who's legally responsible for assuring compliance. So you're going to want to check with them. You're going to want to probably review their forms, review their procedures, and make sure everything is okay, again, consistent with where the law currently is. And finally, if all else doesn't worry you, you want to look at your actual service agreement with that vendor, because that's going to lay out exactly what sort of protections you have if they screw up. I mentioned, again, you're legally responsible, even though you've engaged them. Make sure that you've got suitable indemnification provisions if they, don't provide a proper form, or they assure you of something going on and find out later that they're not doing it. If you take these 3 steps, that other old adage, an ounce of prevention is worth a pound of cure. I think a little time and energy spent now will help, worry less down the road if something should go awry and these COBRA class action litigation cases continue. With that, I'm going to magically move to the next slide ever so slowly and turn it back over to you, Lena.
Thanks, Eric. All right, I am going to talk about a few more impending requirements for group health plan sponsors. So the first one here, I'm sure everyone's caught wind of this in one way or another, but there's been a major congressional push over the past few years to help protect health plan consumers when it comes to healthcare pricing and billing by making things more transparent. Healthcare is one of those weird things where you get a service, you generally have no idea what it costs until you get a bill in the mail weeks later. So adding more transparency to that process of shopping for healthcare and providers is what these rules are intended to do. It's all well and good. Many of the new requirements do come with a lot of extra responsibility for group health plan sponsors. So this slide lists out most of the requirements under the Consolidated Appropriations Act, not all of them. And of course, there's additional requirements imposed on healthcare providers, hospitals, et cetera. So basically what we have here is a bunch of changes to current processes involving billing for out-of-network providers and emergency out-of-network services, ways to resolve out-of-network claims, disclosures to participants regarding balance billing, updated participant ID cards, clarity in the amounts participants are responsible for paying for scheduled services through advanced EOBs. And that requirement itself, enforcement of that is delayed because there's some difficult coordination involved between providers and plans. Required reporting to the government on healthcare spend, accurate provider directories, price comparison tools, publicly available rates, allowed amounts for services and items. Overall, it's quite a bit. And the question is, how's this all getting done? How do employers comply with all this? Because generally they don't have access to the data and tools they'll need to fulfill all of these requirements. So the burden is largely going to fall on carriers and third-party administrators. Although, like with COBRA, and at least in the case of self-insured plans, even when you outsource, plan sponsors are ultimately on the hook to make sure their obligations are met and met on time. So if you sponsor a group health plan and you haven't done this already, we recommend engaging your TPAs in conversations about these rules, making sure they're on track to meet these requirements, revisiting your service agreements to make sure the responsibilities are detailed in there, make sure the indemnification language in there protects you if you're self-insured and your TPA doesn't comply with the rules. If you're fully insured, your carrier should be taking care of most, if not all of this. One of the requirements, it wasn't on that initial slide, but is a GAD clause attestation. So GAD clauses are provisions in a contract, often between a health plan and a TPA, that prohibit a plan from disclosing cost and quality of care information or electronically accessing information like de-identified claims info. And again, these new rules don't want to see any of those GAD clauses. We want to see more transparency, more information flowing. So what plan sponsors have to do is by December 31st of this year, attest to the government that those GAD clauses don't exist in their contracts and that they haven't existed since December 2020. And they have to make that attestation annually. Generally, TPAs and carriers are going to do that on behalf of plan sponsors. There's a portal the government made available to submit the attestation. We have seen a little bit of pushback from TPAs, so it's a good idea to reach out to your TPAs, to your carve-out vendors, your EAP, your behavioral health providers, get assurances that they'll be doing this attestation on your behalf. And if not, you'll need to be prepared to log into the portal. There's a manual that comes with it that tells you how to make the attestation. All right. I did want to give a quick overview and refresher of ACA compliance and reporting, but I think we're running low on time, so I might zip through this and just mention some quick 2023 updates. If you sponsor a group health plan and you have at least 50 or more, at least 50 full-time employees, you're probably well aware that you need to provide affordable healthcare coverage to those employees and comply with reporting requirements. So the updates relate to those reporting requirements, the forms 1094, 1095Cs. They now need to be filed electronically if you have over 10 returns, and that's starting in the 2024 reporting year for 2023 filings. So make sure those are done electronically going forward. There will be penalties associated with paper filings. And we are seeing, I did want to mention, some increased IRS enforcement with respect to inaccurate and incomplete filings. I'll zip right through this. The deadlines for providing employees with their forms, their 1095s, are January 31st. The IRS filing deadlines are a little later, March 31st for electronic filings. Quick mention, a letter 2226J from the IRS means that the IRS is attempting to assess a penalty for failing to comply with the employer mandate. So either you didn't offer coverage the way you were supposed to, or the coverage wasn't affordable or didn't provide minimum value. If you receive one of those letters, the most important thing to do is review it promptly. A response to the IRS is generally due within 30 days. And we've had some good success, arguing that there was reasonable cause for what happened. It's usually a coding error that occurred in the 1095s. And then the IRS will usually reduce or waive the penalty, but it is important to review those promptly and keep good records, because the IRS issues these letters 2 to 3 years after the filings. Make sure you have records of your older 1094s and 1095s, that they're readily accessible if you outsource that, and that you have good employment and offers of coverage records. Okay, I will turn it back over to Steve and his team. I think Anthony's up next.
So yeah, Anthony's
Yeah,
gonna
yeah.
talk a little bit
Thank you
about
so
executive
much.
pay.
Thank you very much, and I appreciate it. I'd like to thank the Nixon Peabody team for all of our compliance updates so far today. Understanding that we are, kind of butting up to the end here. There's a lot of things that we see here at the brokerage. A lot of what we see are, a lot of the executive leadership team looking towards the employees' benefits. And then from there, there's a shift in focus at times. What are the ownership teams doing in order to take care of the leadership teams that work so diligently in order to take care of their business? So there has been, a very large push for an executive level of benefits, and how employers can really, take advantage of the some of the additional benefits in ways that there may be some holes in traditional benefit plan designs. There is obviously a cost share many times, regardless if the plan has, a $0 deductible, or if it has, a $500 or $1,000 deductible. There is still a co-insurance in there. There's still a maximum out of pocket. So we have seen, again, a shift there where you may need to recruit a C-suite, member, or even just a member of your leader, the executive team, or even in your management team. So with that said, we have seen, a push for some of these benefits in order to help, retain or recruit top talent. And with some of those cost shares in the benefit plan design, there are add-ons. There are medical reimbursement accounts that you can, you can class there in order to make sure that you're really attracting that top talent. So for some of those, again, there's a really great add-on coverage on top of the already strength plan design. But then there's also, guiding those that are part of your senior leadership team in order to make sure that they are really getting access to the best care providers within their network, within their area, or even clear across the country. That's a lot we've seen with a lot of our large nationwide providers and their networks, that you could go see the best specialist in the country 3 states away. But ultimately, you want to make sure that that is the best care for yourself or your covered loved one. And then additionally, there's a lot of convenience features and how you would actually use some level of reimbursement there, and how you kind of submit claims if your employer does provide an executive level of benefits that may reimburse you, where you do need to make a co-payment or pay towards your deductible for certain services. So there are also services that we see that are not typically covered, whether you're fully insured, level funded, or even self-funded. We do see that there are services that may not be traditionally covered. Sometimes they are not only medical in some certain scans or high dollar complex imaging, but also sometimes there's medical equipment or even orthotics that are not traditionally covered. So sometimes there is a need from the ownership in order to really strengthen the benefit there, to make sure that they're taking care of those members that are taking care of their business. Also, we do take a look at other things that are not traditionally covered. Some of the ancillary plans, they may not cover adult orthodontia. And if that's the case, there are avenues to go for the employer to make sure that they can reimburse that top talent in order to make sure that they're not left holding a very large bill at the end of the day. And the great thing about these benefits is that it can be carved out like clips. So understanding that you want to attract that top talent, you want to retain that top talent. If that's the case, again, you can carve this benefit out, and there could be a certain benefit amount allotted to make sure that you can take care of the cost for those benefits that may not be covered by your traditional plan design. On top of that, with a lot of these executive level benefits, there are also additional support features. Those support features, such as Top Doc Connect, it'll really match, kind of what your executive or what your top, management team may be dealing with by way of an illness, that maybe they do need to see a certain specialist. They can always reach out to somebody, speak with them directly, talk about the doctors that are in their network, maybe even a doctor that's out of their network. So again, more services there in order to help, your top talent, so to speak, really gain access to those great benefits. Also, there is a Get Me Home. Again, this could be whether it's fully paid, air evacuation for medical security or natural disasters. Those are an additional benefit that we have seen. I mean, we've seen these travel programs provided by ancillary providers as kind of an add-on if you provide your employees certain level of benefits. But this is a really great benefit that, again, it's strictly there 24 hours a day, 7 days a week, 365 days a year for your top talent. So when we look, traditionally, how do you kind of cap this? What does this look like? These benefit amounts, and again, it can be structured, in two very different plans here, depending on the premium that you may like to see. But you will see here that per occurrence, which is every injury, every hospital visit, that there's an out-of-pocket cost. There is a reimbursement for that. And again, it's really whether they use a card for the RX or they're resubmitting that claim to just be reimbursed by their employer for any out-of-pocket expense. And again, this is on top of the plan design. So there are automatically mechanisms in there in the plan design to make sure that the employer is also capitated. So, again, whether it be, per occurrence or if it is, on an annual basis, per covered person, per plan year, because we understand it's not just the executives that are being taken care of by these plans. At times it's also the families that are at home. that, they are also then receiving a greater level of benefit for a reimbursement from the company because of the senior position had by some of the executives in the company. And again, this is per prescription. It could also be used for mental health. As we've seen today, there are a large percentage of out-of-network providers when we talk about mental health or behavioral health. So again, when we think about those out-of-network claims, a great way to reimburse your executives or senior management team is in order to have, some type of medical reimbursement there for them. This can also be used for ancillary benefits. As we've seen year over year, there are just some things that, on the dental side or even on the vision side of things, that those treatments, they're fairly large dollar amounts. So with that large dollar amount, there are ways in order to reimburse your executives or senior management team using these types of medical reimbursement accounts. And again, it's easy to use. So just like somebody would go ahead and submit a claim using their, healthcare FSA or their HSA or their HRA, whatever it may be, it's really about the convenience. Nobody wants to have to go through a huge elongated time period in order for them to submit claims. So they can use it anytime. They can download an app. They can take a picture of it and submit it for reimbursement. So when we look at the overall compensation, now let's say you want to gross up an executive in order to say, what their take-home value would be. And when you look at the actual cost of the company is, as opposed to giving them some type of medical reimbursement outside of what you may do for your rank and file employees, this executive benefit solution, when you look at it, the take-home value far outweighs what you would do on a gross-up situation. So again, when you're looking at the actual take-home value for some of these plans and for a medical reimbursement, there is a tremendous value here beyond, giving somebody an extra $15,000, $20,000 in compensation. So again, that's kind of filling the gaps in the plan designs as it may be today. Even if it is a very strong plan design, there's still co-pays, right? There's still a maximum out of pocket. So those are a great way in those medical reimbursement accounts in order to really build in an executive level of benefit. The other thing that we see, is it does not matter how large the group is. We have groups that are 200, 2,000 and above, that they're still going to have an LTD benefit for all of their employees. And even if you do class out that LTD benefit, there's still some of the employees that are highly compensated that do need a greater level of benefit. And when we take into consideration that 1 in every 6 Americans will experience disability within your working years, again, when it goes into a long-term disability situation, there is a lot more for them to cover on top of the already strong employer benefit for those that are highly compensated. So when we look at long-term disability and what somebody is going to receive until they are deemed disabled by the Social Security Administration, this is a tremendous benefit. So what we do here at Triton Benefits is, we try and take a look at, not only everybody that helps the engine run at your business, but also those decision makers and exactly what they need, from a plan, and also give consideration to all of the hard work and dedication that they've given year over year to making your company great. So I understand that we're running short on time. I don't want to go over speak to time. I want to hand it over to Steve Rosenthal.
Thanks, Anthony. Great job. So we learned how to keep everybody compliant so far, attract, retain top quality leaders with these executive plans. And I'm going to talk a little bit now about some new insurance products and concepts. Typically over the last 20 years, you change deductibles, you change co-pays, you move from Blue Cross, United, Cigna, Aetna. It's a shell game and it's starting to catch up. Every carrier wants to look at the prior year's increase and not going to give you much more. So we got to get very strategic as we tell all of our clients. There's a product out there that just hit the market. It's called Surest. It's owned by United Healthcare, the largest carrier in the country. And it's new and a future wave of promoting member consumerism. These plans have 0 deductible plans, and it only is a copay plan. So when you talk a little bit about these transparency laws, this is like the Kelly Blue Book of medical insurance. And you get to use United Choice Network, which is the largest network. Procedures such as maternity, hip replacement, cancer treatments, it's all done through low copays. And now everything, comes down to crowdsourcing, and now you get to see member experiences and see how these providers are all rated. So you can have a copay for HSS hip replacement for $900 up to $1,500. And when you read the crowdsourcing, you may be pleasantly surprised that the 900 value may be better than the 1,500. And so this all goes to your maximum out of pocket. Typically, the maximum out of pockets could be anywhere from $2,500 to $5,000. And they bundle the claims, which is nice. So like a maternity claim, for example, you typically have the mom's surgery, you have the mom's hospital, the child's hospital, and the anesthesiologist. And it costs anywhere, one bill, no, you won't get 4 bills anymore, anywhere from $400 to $1,500. So this is helping with consumerism. And typically these plans are doing very well with Surest. Usually it's offered alongside as a base plan, and then you have your buy-up plans. So that's why you see you have a 224% employer growth, and you see 126% member growth. So you have still about 50 to 75% of the members using that as a base plan, and then they may want to buy up to a traditional EPO or PPO plan. But typically for the members, 54% lower out-of-pocket costs. And we're seeing the proposals coming in between 15 to 25% and sustainable. We're not looking at these double-digit increases that we've seen over the years. Members still have an option to go out of the network, but they'll pay more in terms of out-of-pocket costs. Unfortunately, the product's listed or licensed in just 12 states, but it's available in all states using the ASO platform. So if you have, Allied, or you have Meritain, or you have UMR as your TPA, you can use these the Surest around the country. And we believe the 12 states will be up to about 18 states within the next 6 months. Gap funding is also another clear strategy to reduce costs. And the whole concept here is just you're getting a higher deductible for a lower premium, and you're funding the difference with gap insurance. So Garner, they're a third-party gap insurance provider, and they work with all the major carriers. And so you can have funding that will take from your current deductible, maybe it's $1,000, and now you're going to put in a $2,500. So you have $1,500 variance there. And to fund that gap insurance, it's anywhere between 10 to 25 cents on the dollar to make the member 100% whole. One of the things I want to talk a little bit about the gap insurance using a company like Garner. You can see the providers are in any of the networks. But if you're going to have a specialist or a surgery, then you need to call Garner to pre-certify. But the overall reduction in premium, we've seen up to 30, even 40%. We also get some reporting on here. So even if you're under the threshold where the carriers will not give you the reporting, we're still able to kind of take a look and see what's under the hood, get some early reactions on some of the RX. And what we see in a lot of cases today, Humira, Stelara, Skyrizi, 45 milligrams, 12,500 a dosage. And if you weigh a few pounds more than you'd like to weigh, you may need 90 milligrams at 25,000. Ladies and gentlemen, this is what's driving up healthcare costs. And it truly is broken. There's rebates that the carriers get that a lot of times you just don't see. So we can get into that in a few moments. But the gap funding using Garner makes a lot of sense. HRA funding strategy. So the next page will focus more in on this Excel doc, but similar to Garner, you can reduce your medical insurance costs by raising the deductible and giving your employees a first dollar benefit. So any employer can do this by funding the difference between the desired deductible to the high deductible, and the net difference 100% HRA utilization, still going to utilize or yield a good savings. And the example I want to give on the next page is, so here's a United Healthcare $1,000 deductible plan on the left, $890 for a single premium, $2,700 for the family premium. You multiply it by the amount of employees, so you have an annual cost of $3,384,792. When you raise this to a $2,500 deductible, you could be looking at costs of $650 for the single, $2,100 for the family, and that will yield out about $2,667,000 in annual premium. So you see, this is a $717,000 reduction. Now, obviously, you're going to have some pretty upset employees telling them they got to satisfy a $2,500 deductible first. So what we look to do is we take the difference between the 1,000 and the 25, and we use 1,500, and for the family, 3,000 to fund these the difference in deductible. So on the 125 singles and the 77 with dependents, at 100%, that's $418,500. Data tells us that 50% HRA cap is on the high end. So that's why when you look at Gardner, they typically charge 25 cents on the dollar for something like this. You'll have some brokerage firms out there, they'll stand behind it, they'll have some skin in the game. And so at 50%, your liability is $209,250. So when you add that to the savings by the reduction in premium of $717, you're going to net out over $507,000 savings. And I got to tell you, this is real. We do this every day, and it's a win-win situation for everyone. And again, we get to look with the HRA, we get to see what's under the hood and see what some of these early claims are telling us. And captive insurance is relatively new for the most part. Companies typically use captive insurance for their workers' comp, property and casualty insurance. But the last few years, we've seen the rise. We've seen Berkeley captive, Pareto captive, and you're really taking the parent, which is the company, and they're making payments to the captive, and the captive in turn is moving it back to the company based on certain levers. So how these levers work, layer one on the captive is your traditional specific stop loss. So these are self-funded plans, and you own part of the reinsurance as a captive member. So let's say a company has a specific stop loss of $50,000. You still pay up to $50,000 in a given claim per person per calendar year. So if John has premature or has some issues going on, whatever it may be, you pay only up to $50,000 and the reinsurance kicks in. In this case, the captive would kick in. Larger groups may have $100,000 specific stop loss. So the layer two would be the claims that are above the client specific stop loss, and it's paid by the captive until the captive threshold is met. And then comes a third layer, and that third layer is really the captive working with a third party reinsurance company like an HCC or a Sun Life. And so this level two creates a shock absorber. Anything left over in layer two gets distributed into the capital accounts of the captive members. So we've been selling a lot of this, and the reason why, it's the control over the RX. So I'll take the nation's largest TPA, UMR, owned by United Healthcare, who also owns Optum RX. So they have a vested interest to put everything through OptumX, because those high-priced drugs that I mentioned, they get a nice rebate that comes back. And when you can kind of, carve this out a little bit and not use, these programs, you may be able to go to your PBM, your pharmacy benefit manager, and use international RX sourcing, patient assistance programs, rebates in generals. And again, these are big dollars. I mean, $50,000 drugs, you're seeing up to $20,000, $30,000 coming back, in terms of rebates. And it's just a great way to control your costs. And here's some information. So, I'd like to, before I get in, we have a couple of questions, but again, I'd like to thank everyone for participating today. As mentioned earlier, if you're interested in obtaining a copy of the presentation, please send us an email and we'll forward it to you shortly. Should you ever need any legal advice or insurance guidance, please always feel free to reach out to Nixon Peabody or our firm if you just want to, run something by us as well. So we just have a couple of questions, and I'm going to head to it. And I think one of the questions was answered already. I think, Mike, you answered the question regarding pay transparency and if it should be posted or should companies stop.
Yeah, it's a specific question of if you're not in a jurisdiction that requires disclosure under a pay transparency law, should you continue to do it if you already are? So that becomes more of to me, that seems more of a business judgment decision about whether or not there are competitive advantages for posting it. Does that set you apart from other potential employers? Of course, there's countervailing issues too with making that kind of information public. So I think it'll become more and more common, and employees or applicants will expect to see it, but whether or not you do it in the absence of a legal requirement has a balancing aspect to it.
And I just wanted to make sure I read out that actual code. So I just want to go back a slide on here if you guys can control that. We'll just make sure everyone has the code for the continuing ed. One more. Just want to go back one more slide.